Okay, so just to give you a little overview of today's presentation, we're going to go over the changes to state and local law. We're going to go over common pitfalls for employers regarding the recent minimum wage increases. We're going to go over how to avoid falling into the trap of common pitfalls and some strategies employers can use. There will be discussion on potential liability for employers who fail to comply with applicable minimum wage requirements. And then at the end, we'll have some time for questions and answers. Recent changes to California law. Does anyone know California's current minimum wage? What is it? 10, very good. And this applies to all employees, whether full-time or part-time. Although there is a federal minimum wage requirement, it is less than California's mandated wage. Does anybody know the federal minimum wage? $7.25, yes. So California previously instituted a two-step increase in the state-mandated minimum wage. July 1st, 2014 was the effective date of the increase of California minimum wage to $9 per hour. And then effective January 2016 was our current $10 an hour rate. This year, State Bill 3 was signed into law, which will increase the minimum wage in California to $15 per hour by 2022 for large employers. A large employer is considered anyone employing 26 or more employees. And a smaller employer is considered 25 or fewer employees. And for smaller companies, you'll have an extra year to comply. So by 2023, everyone will be at $15 per hour. Let's see here. So, California's minimum wage is actually quite complicated. Section 4A of the Industrial Welfare Commissioner wage orders requires pay at the minimum wage for all hours worked. What does all hours worked mean? This means time which employees are under the control of their employer, such as training time, travel time, and time which they're required to be sufficiently controlled standby. Employers commonly have a few issues with this. One is on-call time. So for example, if you have a receptionist who's answering your phone and you tell her you can take a lunch break anytime you want, 30 minutes, you're good to go. But if the phone rings, just make sure you answer it. That's not considered a valid meal period. You have to give the employee 30 minutes uninterrupted time where you as the employer does not have control over the employee for that 30 minutes. Another common mistake employers try to make is where they try to average the amount of hours worked. So for example, I had somebody come to me and say, well, I pay $20 an hour, which is twice the minimum wage, and the employee works for 8 hours a day, and then they're also required to be on call for an additional 8 hours a day. And so if you just take the average of the total amount of hours worked and the total amount of time worked, it becomes more than minimum wage and you're fine. That's actually not the case. That's not allowed in California. Employers make that argument, but that's not allowed. You're not allowed to average the amount of time an employee works for you in order to scapegoat the minimum wage requirement. So, local cities and counties have enacted their own minimum wage, LA County included, which is why it's so vital that we cover this area. The LA County Board of Supervisors, as we all know, voted to increase the wage in the unincorporated areas of LA County over the course of the next 5 years. So it's just like California as a whole, but they're increasing the minimum wage sooner. In case you don't know, here's a map of the unincorporated areas highlighted in yellow. Yellow, and then white is the sorry, the opposite, yes. The unincorporated are white, thank you, and the incorporated are yellow. So, does anyone know the minimum wage in LA County? It's presently $10.50 an hour, and this came into effect July 1st of this year. The minimum wage will rise to $15 per hour by July 1st of 2020 for large employers. And then, of course, if you're a smaller employer, you have another year to comply. So July 1st of 2017, it's going to increase to $12 an hour. July 1st of 2018, $13.25, $14.25 the following year. And then July 1st of 2020, it increases to $15 per hour. If you are in the city of LA, Mayor Garcetti signed into law a measure which creates a special minimum wage in the city of LA. Note that these do not impact the other 87 cities in LA County. So if you're, so you can always call your local government agency and figure out which laws are in effect in your specific city, but this is hopefully gives you some sort of idea. And then beginning January 1st, 2022, after all of these minimum wage increases go into effect, the county's chief executive officer is going to determine the adjusted rates for minimum wage based on the consumer price index. So it most likely means that it will just continue going up. And like I said, I urge you all to contact your local city office, and they can answer any questions you have about your particular city in a second. Let's see here. So the city also has scheduled regular minimum wage increases to occur tied to the LA Consumer Price Index. The only exemptions and limitations on the LA City minimum wage requirements are as follows. Small employers with 25 or fewer employees in the city of LA have an additional year to comply with the increase. Nonprofits with 25 or fewer employees can apply for the waiver for the later scheduled increases tied to the LA Consumer Price Index if you meet certain requirements. And then 3, employers subject to certain collective bargaining agreements. Employers of employees who have collective bargaining agreements must still comply with the California minimum wage requirements. So these county and city-specific wage requirements mean that employers located in these areas cannot just pay California minimum wage of $10 per hour. They must pay the minimum wage required by their county or city, which of course makes sense. Employers in those and other areas should really stay abreast of the current proposals to increase the minimum wage in your specific jurisdiction. Employees generally cannot waive the right to receive minimum wage by agreement or contract or collective bargaining agreement. So these laws are very strict in the sense that when they go into effect, you must comply with them. Many other cities in California besides LA have been enacting their own minimum wage obligations. For example, both West Hollywood and Santa Monica have established a minimum wage of $10.50 per hour, with annual increases for both cities to reach $15 an hour by July 1st of 2020. So let's go over some common pitfalls for employers related to recent minimum wage increases. Some things include failure to recognize the impact of new minimum wage requirements on the classification of employees as exempt from applicable labor code requirements. Failure to pay accurate overtime rates, failure to provide written notice to those employees regarding the change in rate, and lastly, failure to post the current wage order in your place of business. So, the impact on classification of exempt employees. Increase in California minimum wage also changes the minimum salary for exempt employees. everyone understands exempt. You're exempt from the minimum wage. Under both state and federal laws, employees are either exempt or non-exempt from the labor code regulations, which includes but is not limited to overtime laws and minimum wage laws. And therefore, they're entitled to receive overtime and no less than minimum wage for an hour's work. So there's a two-part test to determine whether an employee is exempt from these labor code provisions. Okay, the first is based on salary. The second is based on duties. Under the salary test, an exempt employee must be paid a minimum weekly salary of at least twice the current state minimum wage in order to be exempt from overtime and minimum wage requirements. Due to our limited amount of time here today, we're going to be focused primarily on salary. I'll go into a little bit of the duties test just so you have a general understanding of the test, with relationship to the duties. And the most common types of duties exemptions are executive, professional, and administrative. I will note on both parts just so everyone sort of understands what must be satisfied in order to properly classify an employee as exempt. So, the language in Labor Code Section 515 reads in part, the Industrial Welfare Commission may establish exemptions from the requirement that an overtime rate of compensation be paid and earn a monthly salary equivalent to no less than 2 times the state minimum wage for full-time employment. Why is this important? This means that the state minimum wage increases, and so will the minimum salary requirements for exemption of employees in your business. Practical advice, never assume your employees are exempt from their overtime simply because they're being paid a salary or simply because you use the term manager in their position. These types of incorrect assumptions have cost employers hundreds of millions of dollars, if not billions. And just to touch on a recent case, the Halliburton case, incorrect assumptions just recently cost Halliburton $18.3 million. This error resulted in just 28 employee positions and 1,106 employees being incorrectly classified as exempt from overtime. Halliburton was forced to negotiate with the U.S. Department of Labor and ultimately pay approximately $18.3 million, $18,000 per worker, in back overtime from the Department of Labor's audit of their practice. If this case had been in legislation as opposed to up in front of the Department of Labor, it would have cost millions and millions upon millions of dollars. And some of the things on why it's so much more expensive in the litigation process is because attorney's fees have to be accounted for, and it can really impact a small business and potentially put them out. So the impact of minimum wage increases of classification for employers. Effective January 1st, 2016, the state of California enacted the minimum salary, which is $3,466.67 per month, or $41,600 a year.
Can you repeat that, please?
Yes. It's $41,600 a year, effective in the state of California as of January 1st of this year. I'm sorry?
That's a minimum salary?
Yes. And then it goes up in January. January 1st of 2017, it's going to be $43,680 per year. And that comes out to $3,640 a month.
So what is the deal with the Department of Labor minimum salary? Isn't that $47,460, and does that supersede the California minimum salary?
Yes. Sorry, I'm going over some background. So the minimums have to be met through base salary only, not total compensation. So if you give your employee a $10,000 bonus, or if you give your employee health benefits or parking or whatever other benefits that come under the pay that you pay your employees, those things do not count. It has to be based on your base or target salary.
How many hours? That's base salaries?
That's 40 hours a week.
40 hours?
Yes. So, yeah, beginning, so different amounts apply under the Federal Fair Labor Standards Act for exemptions for executive, administrative, and professional employees. The new requirement under FLSA is the minimum salary level of $913 a week or $47,476. Yes?
Based on that, in regards to the payroll a business has, it would behoove any business not to have an HR department. A lot of these questions can be answered in the HR department.
I highly recommend HR departments as long as they're coherent and up to date with the legal standards. The problem that we sometimes find is that somebody who's not well versed or isn't up on the laws, they spend a lot of time researching and figuring out in your specific city and hours and hours and hours where you're kind of being billed for something while they figure it out.
Yeah, this is
but
an HR department can do it.
absolutely. And HR and employment law heavily, coincide, and we're both on behalf of helping the employers. Excellent point. So just a note on the FLSA requirement. The U.S. Department of Labor intends to thereafter automatically increase the salary minimum test in future increments that will prevent it from being outdated, and employers expect to anticipate these automatic increases, which will be indexed to the 40th percentile of weekly earnings for full-time salaried employees in the United States.
But if a salary employee works 50 hours a week, then what would you do?
Well, if they're salaried and they meet the duties test, they're exempt from minimum wage and from overtime. You're right. Yeah. So here's a quick story about the Nurgri versus Koenig and Associates. Nurgri was an insurance claims adjuster, and I tried to portray that here. His pay was $29 per hour, and the law requires a salary, which is a fixed, predetermined, guaranteed amount not subject to deduction. The salary is also not based on pay or total compensation. So because he was not a salary, he's not exempt. Therefore, he is entitled to any overtime pay that he's required to. So if the salary requirement is not met or doesn't meet the minimum, then duties don't matter, and the employee is not considered exempt from those laws. So strategies to avoid misclassification of employees due to minimum wage increases. I highly recommend you speak to your legal counsel just to confirm that you're currently applying the salary test properly to your employees, or if you have an HR department, make sure that they're doing the same. Your legal counsel will also examine your employees' duties to make sure that they meet the requirements of the duties test under the exemption you are applying for to that particular individual of your company. I suggest you calendar an annual check-in with your legal counsel, or if you have an HR department, to ensure that all salaries of exempt employees meet the then current salary test. Consider timing this check prior to your annual performance reviews, so that if you do your reviews every August, maybe you check with your attorney or HR department the month before, so that any salary increases of exempt employees can take the new minimum wages into account. Just to give you a quick example, we had a client come to us towards the end of last year, just prior to the new minimum wage taking effect. The employee was classified as exempt as he was earning an annual salary of $35,000 per year, but also regularly earned a merit bonus of almost $10,000 per year. Our client, when he came to us, thought that because the employee's W-2 indicated income over the threshold amount of the $41,600 at the time, that the employee still met the requirements to be an exempt employee. Our client was wrong. The employee's base salary was below the threshold amount, and therefore, to meet the salary basis test, therefore he failed to meet the salary basis test to be an exempt employee. Moving right along. So failure to pay accurate overtime wages. Under California law, overtime pay is required as follows. I'm sure we all know this, but 1.5 times the employee's regular hourly rate is required for all hours worked for more than 8 hours in a day, up to 12 hours. And then after 12 hours, the pay doubles. For the first 8 hours on the 7th consecutive day of work, you're required to pay time and a half. Double the employee's hourly rate is required for all hours worked in excess of 12 hours a day, and for all hours worked in excess of the 8 hours on the 7th day of work. So, some common pitfalls for employers: leaving out-of-date wage rates in payroll systems, resulting in failure to pay proper overtime to employees, and if employees are misclassified as exempt, failing to pay required overtime to those misclassified employees. So, strategies to avoid some missteps related to payment of proper overtime rates. Once again, schedule to speak to your legal counsel to confirm that you are currently applying the proper overtime rates to your employees. This will be in conjunction with the analysis of the exempt versus non-exempt status of your employees. Calendar a 4th quarter update to payroll systems to ensure that all pay hourly rates of employees are updated to meet or exceed the then current minimum wage requirements, and make sure that all overtime rates are updated in your system as well. Another example, a client came to us and had an employee who was paid on an hourly basis, but he was considered a manager. And so the client automatically classified the employee as exempt, being exempt from all overtime and minimum wage requirements. The client paid the employee for all hours worked, whether it was 2 hours or 10 hours each day, but never paid the employee overtime. As we discussed earlier, the classification of manager does not necessarily make the employee exempt. An employee cannot be paid on an hourly basis and still be considered an exempt employee. We advised our client to immediately change the employee's classification and calculate all back wages and overtime owed to this particular employee in order to pay the employee the amount owed to it under the law. Had our client not been proactive about this situation, it could have exposed significant liability on their behalf, because as we'll get into later, not only is the business liable, but the business owner can now also be held personally liable for not knowing these types of minimum wage requirements. So just real quick, to go over the most common types of exemptions. Yeah?
I have a question on the personal liability of the owner. Is that even if it's a corporation?
Yes.
Okay.
Yes.
No matter what type of corporation?
Yeah. Corporation, LLC, whatever type of entity you have set up, you can still be personally liable as an employer. Sure.
What about the property owner in a judgment?
What do you mean about...
Well, in the car wash industry, there have been a lot of violations.
Mm-hmm.
And there have been some judgments, $150,000. And they give the next tenant 1 year probation, conditional permit.
Mm-hmm.
But the threat is there that the property owner is going to have to pick up this $150,000 judgment.
The property owner, who was the judgment against? The car wash, the tenant? And the property owner is required to pay the judgment or just have the repercussions?
Talking about in the car wash industry that there's an accession liability, which I think is totally unfair because you lose your tenant.
Of course.
Conditional permit.
Right.
And sometimes your property can just sit.
Right, yeah.
That's happening
It's not...
to a bunch of properties.
It's not fair at all. Yeah.
When did the liability for individual owners go into effect?
January of this year. Mm-hmm. Yeah.
About that. You're saying corporations, LLC members, and shareholders are personally held liable?
So we can get into...
Corporations liable?
No. So if you're... this primarily takes effect if the property... Or, sorry, not the property. The business owner is a... Let's just say an S Corp. So to give you an example, I'm an S Corp with my business. And if I have employees who are not being paid overtime and I know about it and I manage those employees, I can be personally responsible myself, even though I have a corporation. So both of us are being sued now.
So you're talking about if you intentionally...
Exactly.
Okay,
Yeah.
That's what I was confused.
Yeah.
So it's only if you know about it?
It's if you know, we can go into a little bit more detail maybe at the end, but it's if you are aware of it and you're...
It being the law, or it being the fact that your employees aren't being paid from?
Knowing the law doesn't matter whether you know it or not. It's that not knowing the law is not an excuse for not complying with those requirements. So it's not necessarily knowing it. It's that the way you are managing it isn't in compliance, and therefore you can be personally liable.
You have to have intent for that?
That's a good question. It's more of that the policies you have in place as a small business owner, regardless of whether or not you know, are not in compliance.
So I guess it's more like you didn't take the measures in order
Exactly.
to be compliant, and so therefore not knowing the law necessarily, you knowingly did not seek the help.
Exactly. Yes.
So that I understand.
Yes. Okay, so just to give you some common... Okay. Just to go over the three most common types of exemption under the duties test. So we kind of covered salary, now we're going into duties. A California employee qualifies for the executive exception, which is generally known as the manager's exemption. If they manage the business, they regularly exercise discretion and independent judgment. They direct the work of 2 or more employees. They have the authority to hire, fire, and advance or promote employees. And they earn a monthly salary equal to at least twice the state minimum wage for full-time employment, 40 hours a week. Another common exemption is the administrative exemption, which primarily performs non-manual work directly related to general business operations of the organization, regularly exercises discretion and independent judgment, has obtained special training, experience, or knowledge, and earns a monthly salary equal to 2 times the California minimum wage for full-time employment. And then another common exemption is the professional exemption. So if you have a license or certification by the state of California, you work primarily in the practice of law, medicine, dentistry, optometry, architecture, engineering, teaching, and accounting. You have advanced knowledge typically acquired by a course of special study. You regularly exercise independent judgment and your own discretion, and you earn a monthly salary of at least 2 times the state minimum wage for full-time employment.
Is there also an exemption for outside sales positions?
There is, yes.
And what would make what's the test to differentiate an outside sales position from an inside sales position?
You know what, that's incredibly... That's going down like a whole other path. I'm happy to talk to you about it a little bit later, or give you some guidance after this. But yeah, sales is a little different, and the commission structure. So, great point though. Let's see here. Notice requirements for employers, how to avoid some missteps. You have to provide your employees written notice of the change in rate of pay. So under Labor Code Section 2810.5, an employer must provide written notice to employees within 7 calendar days after changes made to the number of items, including but not limited to the employee's rate of pay and overtime pay. Going forward, this means that no later than January of 2017 and every subsequent date where the change is made to the hourly employee, each employee impacted by this increase must be provided a written notice reflecting the change. And this can be given to them in a proper itemized wage statement. Employers also, as I'm sure all of you know, must post that big poster in an area that's common to where the employees frequent. So it's oftentimes done in the break or lunchroom. And the current official notice includes the increase which took effect this year. However, new notice is obviously going to be needed in January of next year, 2017. These posters are pretty easy to get. If you don't already have them, you can just find them online. Okay. Everyone's favorite, liability. Let's see here. Under California law, if an employer does not pay an employee correctly, they can expect to see some or more of the following claims: failure to pay minimum wage for off-the-clock work or hours that may not have been recorded on time, failure to pay wages for hours worked, failure to pay overtime, wage time penalties, which is up to 30 days in wages, pay stub violations, up to $4,000 in penalties or damages, failure to keep accurate records. Remember, you as the employer have the responsibility and the duty to have records on your employees. And so you just want to make sure the top 3 rules are document, document, and document. Make sure everything is documented. Penalty claims under the Private Attorney General's Act, liquidated damages, missed meal period penalties, and just to give you a frame of reference, for every missed meal period, it's an additional 1 hour of time per day missed. And then also missed rest break periods. Even though an employee... Yes. So drivers are a little bit different as well, but I would still say if you have drivers on your staff, have them keep track of their breaks and lunches. I mean, obviously their lunches, but also their breaks. It's so easy to implement as an employer. It's just a quick spreadsheet. You do time in, time out, 10-minute breaks collected every 2 weeks. It's the easiest thing to just save you time and energy and headache later on. It's the easiest way to document. And it's something you can implement tomorrow. So, there's that. So, I was just at missed rest periods. And a rest period is required, 10 minutes in the morning, 10 minutes in the afternoon, in a normal 8-hour shift. Of course, there are specifics for when those rest periods have to be taken. But every rest period not taken is a 1-hour penalty for you, the employer. So even though there's 2 rest periods in a day, they sort of cut you a break in the sense that you're only being penalized for 1. Just something to note, I guess. And then violation of Business and Professions Code 17200, restitution and injunctive relief, interest and attorney's fees. And both of those things can really add up. Even if you have somebody who you owe, $3,000 or $4,000 in actual missed meal periods and break times, it can just exponentially add up when you account for attorney's fees, interest, everything else under the sun. So you just really want to be cautious of that. And even though you technically don't have the burden as an employer to keep track of breaks, I strongly suggest you do. Like I said, it doesn't take too much to implement. So here are a few cases of examples of recent settlements where employees allege that their employers failed to comply with California labor laws. 1, a single employee sued his employer for 2 years for failure to pay minimum wage and failure to pay overtime duties for off-the-clock work and misclassification. This employee had significant disciplinary history and was, to put it mildly, not the model employee. However, failure to pay the minimum wage is not dependent on the employee being perfect. You must pay them for all hours worked unless they are properly classified as exempt. The employer ended up settling the case for $60,000 for a single employee. Just to give you, I guess, another example where I have this client, he's been in business for 45 years. They do manufacturing of sheet metal. And his employees came to him last year, and his manager had just died. He's been in business forever. He doesn't care if they bring their dogs to work. He's so laid back, so easy to work with. And his employees came to him collectively as a group and said, hey, instead of taking 2 meal periods or rest periods, one in the morning, one in the afternoon, can we just lump them together and take a 20-minute break in the morning? He said, sure, why not? Now he's being sued with a class action case for all employees. And it just breaks my heart because this so easily could have been avoided, and the laws are so in favor of employees. So make note not to do that. Another case, yeah.
The 20 minutes together is not an exemption.
It's not allowed. It's not allowed at all. It's not allowed. I also represent a lot of restaurants, and we have this restaurant that's in Santa Monica, and this is a crazy case, but they had this cook that they would pay under the table, and they wouldn't keep track of all hours worked, and he worked for her for about 2 years. And right a few weeks before he was let go, he came to her and said, hey, you know what, my social security number changed, my name changed, I'm going to go by this person from now on. And she's like, what? I've been calling you, X for the last 2 years. What do you mean you just changed your social and your name? Well, he had given her his cousin's information, and so he was using his cousin's name and social security number for the last few years, and just at the tail end of his employment decided he wanted to come clean with the employer. That didn't matter when we were in front of the judge. It doesn't matter. That employee, even though he, has a whole host of immigration issues, it didn't matter that he was the one who could prove that he wasn't being paid correctly. And so that case ended up settling for $80,000. And that was one cook at a restaurant. So it's just very sad. But another case I was going to get into, a recent California fast food franchise paid almost $1 million, $995, for minimum wage violations under the Fair Labor Standards Act when it failed to pay its delivery drivers the vehicle expenses, making the hourly rate fall below minimum wage. And then another case, the last one, a settlement of $4.9 million was just reached in a class action lawsuit filed by an insurance adjuster against the insurance company. The adjusters allegedly failed to properly pay overtime, violation of California meal and rest period laws, as well as unfair competition. So, I can only stress to you guys to just document as much as you can with wages, with breaks, with meal periods, and also if employees are late, just document everything. It's worth having a file this thick when you give it to your attorney and when you're being sued, rather than not have anything on the employee. And if you say, well, they were a bad employee, they were always late, well, I can't, your lawyer won't be able to use that really unless you get it from deposition testimony, which is just another layer of he said versus she said, as opposed to having written documentation that was taken at the time the employee was actually working for you. And let me give you one more example, because like I said, I represent a lot of employers and restaurants, and we're representing a restaurant right now, and he's being sued by a current employee and a former employee. 2 different lawsuits, 2 different lawyers that we're dealing with as opposing counsel. And, we were able to settle the current employee, and my client didn't know of the wage and hour laws and didn't keep track of breaks and lunches and things like that. And as a restaurant owner, I totally get it. It's hard to give your employees a break time at 8 o'clock on a Friday night, but you just have to if that's when their break time comes. So we were able to settle one of the cases for under $10,000, which I think the other attorney, don't repeat this, but may have committed malpractice because the case was actually worth about $300,000, and which is why I also recommend you find someone very specialized in this type of law, just for you as the business owner. And the former employee, we're still working on settlement, but it should be soon, so that's a plus. Yeah.
Somebody starts working at 9 o'clock in the morning. What time should be their lunch then?
Well, so they have to start so if they're working an 8-hour day, they have to start their meal period prior to hour 5. So if they start at 9, they have to start their meal period prior to 2 p.m.
But if they do it at 3 o'clock or something.
That's not okay. No. And it's also not okay to give them a 29-minute break. They have to have a 30-minute break. So there's a lot of technicalities of when, but...
Is the Brinker case pretty much irrelevant now?
It was huge when it came out. I think that was maybe 8 years ago. And Brinker's still a part of it. It's just, I think as you have a duty as an employer to really just document, because the burden is on you. And then
Maybe send a text message saying, take your break now.
yeah, exactly.
Satisfying.
Yeah, exactly. So you can have them sign things. You can do workarounds, and I'm just focusing on primarily on the general and what to do.
Which case are you referring to?
Brinker.
No, you said it was irrelevant, though?
No, I was asking if it's no longer relevant, but it's still relevant. You just have to make an effort you have to give.
Them the opportunity to take the break.
If the employee refuses to take it, then that's on them.
Right, yes. But document that. There's no reason not to. Say, a lot of my clients just have a small thing at the bottom when they pick up their paycheck that they were given the right to all their breaks, during those last few weeks. And so there are small things you can do to just help you in the event a lawsuit does happen.
Is there currently a business insurance policy for these people who want to cover themselves for anything that employees might do to them?
Yes, and I'm so happy you brought that up. I was going to mention there's EPLI Insurance and Directors and Officers Insurance. And I'm sorry?
Which are not cheap.
No, which are not cheap, but it even makes our life as attorneys so much easier when they do have that type of insurance. Because you can get a settlement a little bit quicker and kind of get rid of the case a little bit sooner. But definitely, I recommend everyone check into both types of insurance if you don't already have it.
Standardized insurance or just a specialty that just some company is offering?
You're going to have to talk to your specific insurance agent. I have someone that I refer for EPLI, so I'm happy to refer them to anybody who's interested. Sure.
When you talk about exempt employees, whether they work 40 hours or 50 hours, what if they work 80 hours and then those hours are actually lower than, in theory, the minimum wage? It just doesn't matter if you're exempt how many hours you work, or is there a cutoff?
So that was going back to the example I kind of gave earlier where employers sometimes try to average it. So if you do averaging it doesn't help, but I guess you're asking that if they are exempt.
Can they work 80 hours?
Yeah. Oh, yeah.
Even if it, in theory, would be less if you divide
If they're properly exempt. You just want to make sure that they're properly exempt. So a common profession are, architects or lawyers or a professional who oftentimes does work 80 hours a week and they're not paid for overtime.
So on the lunch break, if an employee is not, it's not possible to relieve the employee of all duties, let's say a single person on a single shift,
Mm-hmm.
if they've been given the allocated time, 30 minutes, to take a lunch break, if it's interrupted and they add time on, I believe that's called a standing lunch, right? Is that legal?
I would suggest against it. There are certain things maybe you can do like 6-hour shifts so that, because if somebody works a 6-hour shift, you don't have to give them a lunch break. And I would suggest maybe cutting it down to 2 6-hour shifts or something like that, just so you don't have any issues later on. But if if you have somebody like my example earlier of the receptionist who's, able to leave her desk, but if the phone rings, she has to answer it, that's not a proper lunch break. So you just want to be careful on the exact duties of the employee.
So I have been challenged on this particular.
Oh, great. Yeah.
And I didn't go to a lawyer, but it was through the Employment Development Department. And I laid the facts out, and it was ruled in my favor.
Great.
So I don't
So
know if it stands up in court or if it goes to attorneys, does that stand out?
I would probably want to look into your specific business and your specific situation in a little more detail, and I'm happy to talk with you about it afterwards. But that's great. You were able to get rid of an audit like that or a claim like that. So very good. And then so there's a risk of both civil and statutory penalties under various labor code provisions. Not only is the employer potentially personally liable, there's also a recent move to try and hold individuals liable for penalties against those who caused the violations to occur. So right now it's the owner, but it may also be in the future that specific manager who allowed the violations. Under California Business Code Section 17200, employees can assert various wage claims going back up to 4 years. And this includes claims for wages, meal breaks, rest periods, overtime, minimum wage, failure to pay all wages. Generally, labor code claims go back 3 years, but it just depends on the particular issues at stake. So you're looking at 3 to 4 years. How much time?
It's almost fine.
Okay, perfect. Thank you. So just make sure you watch out for the reoccurring issues that still drive claims and lawsuits. Misclassification. Are you improperly dividing employees based on salary and hourly versus exempt or non-exempt? Have you reviewed the base salary for your exempt employees? Semi-monthly pay periods. Are you always paying the same to non-exempt employees? If so, proceed with caution. Review timekeeping systems. Do you have a policy in place which prohibits off-the-clock work? Do you have a complaint procedure for employees? Should someone ask them to do off-the-clock work? If not now is the time to implement those things. So everyone should have an employee handbook, and these things should all be laid out within there. Rate of pay. Are all hours worked by the employee included at the proper rate of pay? Are you complying with state and federal overtime laws? Note, proceed with caution when considering taking on unpaid interns in California. Please do that. Itemized wage payment statement is everything there. And employment agreements. Do any of your employment agreements provide for a rate of pay less than the current minimum wage? Employees cannot agree to work for less than the required minimum wage. So, and any agreement that says otherwise, that your employee will work for $9 an hour as opposed to $10 is void under the law. All right. Well, that concludes my presentation. Yeah.
Who are the agencies that are enforcing these laws, and are they actively auditing our businesses, or is it like a disgruntled employee that would blow the whistle and that's the way?
Good question. It's generally a disgruntled employee, but even though all your employees you're on good terms with, everybody likes you, you've been working with them for years and years and years, it doesn't mean that at one point you may have a problem with a claim like this. In fact, I had a client a few years ago where I told him, let me just give you this simple spreadsheet of just clock in, clock out. You just have them write it in. It's the best measure. You don't need something fancy with a thumbprint. Just handwrite in and out. And I told him, implement this. He's like, no, I run a computer company and, it's totally fine. All my employees really like me. I like all of them. And then he gets a call about 2 years later, like freaking out that somebody is saying, you know, we have a problem, I wasn't given my breaks. And it just is so easily avoided. So even if you create your own Excel spreadsheet of just time in, time out, and just have your employees write their name and the times, it could just avoid so many problems later. So yeah, the agencies aren't creating, you know, general audit. It's generally when a disgruntled employee, you know, has an issue.
So the 6-hour shift, the meal break waiver, all the break times and the laws that pertain to break, lunch and coffee breaks, lunch breaks, or whatever, if they're part of your handbook and the employee acknowledges and signs for receiving that handbook, is that actual documentation that needs to be done throughout?
It's good documentation. You want to make sure that, you know, for those of you who have employee handbooks, and I hope everybody does, that you have the employee sign off that they read it and that they understand it. But, you know, there's just little language you can put in, you know, prior to them even receiving their check, or, you know, anything that says, I have been given an opportunity to take my lunches and breaks, and if I haven't taken them, I've waived that right. So there are certain waivers you can think about putting in place, but the best thing is just to document everything.
Are electronic records considered proper documentation?
Yes. Yeah. All right. Well, thank you so much, guys, for having me here today. And thank you. I appreciate it.